Good evening, everybody. This is Akansha Singh, your mentor and faculty from Livelaw Academy for the Judicial Services Examination Preparation course. I welcome you all to our lecture series, which we have focusedly made and prepared on the concept of compensation. And I'll be teaching all these civil laws. That is the reason we have picked the subject like Indian Contract Act, which is covered majorly in all the state examination related to judiciary, as well as its importance can be seen with the number of questions that have been asked in the past, be it previous year, multiple choice questions, or the subjective questions. So today, in the series of this discussion, we'll be talking about compensation which is to be granted for breach of contract. Now let's understand why this topic has been picked specifically with respect to compensation. We understand the relevance of contract and the contractual liabilities. But at the same time, it is also very important that what will be the remedy that will be given to the parties when there is a breach of contract that occurs. Now, to get those set of remedies, we have different laws. We have Indian Contract Act. We have certain remedies given under Specific Relief Act. We also have CPC granting us certain set of remedies. We have picked one such remedy here in today's class discussion, which we will continue for the next 2 days, specifically hinting on the concept of compensation granted and allowed under Indian Contract Act. Now, if you refer to Chapter 6 of the Indian Contract Act, I'll just open the Bare Act for you to get an idea as to what is the title of this Chapter 6 of Indian Contract Act. Now, you refer to this. Chapter 6 says of the consequences of breach of contract. So, if there is a breach of contract, what are the consequences? Now, refer to the title of Section 73. Compensation is to be granted for loss or damage caused by a breach of contract. Then another starking important factor under Section 73 is that it has various illustrations. Now, if you start counting, you will find out that there are 18 illustrations which are supporting this provision, making it very much valid for us to refer to these illustrations to understand the concept of compensation to be granted under Section 73. Now, if you refer to the title of Section 74, it says compensation for breach of contract where penalty is stipulated for. That gives us an idea that the provision related to penalty or the idea of penalty is codified under Section 74, which is absolutely different from 73. But is there any similarity? Is there any principle that we have to refer and compare between 73 and 74? That is what we are going to discuss in our next section, next class for this particular section. Not just this, we also have Section 75, which is the last provision under this chapter, which talks about party rightfully rescinding a contract entitled to compensation. So you can be granted a compensation when you have rightfully rescinded a contract, right? So very holistically, Section 73, 74, and 75 under the Indian Contract Act covers the idea of consequences of breach of contract. But if you are a judiciary aspirant, I would like to highlight and tell you again, this is only specific remedy granted under Indian Contract Act. Okay, so when you join our course, we'll be discussing of all set of remedies. When you get a question, a subjective question, you have to mindfully assess and you have to give your answer looking at the question and the idea of the question maker as to what is the remedy that they are expecting us to mention there for that particular question. So here, restricting ourselves to today's discussion, compensation for breach of contract, an in-depth study of Section 73 of the Indian Contract Act. The reason of us doing this exercise here of comparing 73, 74, 75 is for me to tell you that today's class is going to be restricted to only Section 73. We will discuss the idea of liquidated damages, the term penalty that you just come across, all these in the coming classes that will happen tomorrow as well as day after. So please stick with us and try to be attentive and try to interact with us in the comment section. I'll take up your questions at the end of the lecture. And also, if you have any questions which comes later, you can drop it in the comment section and I'll be more than happy to answer it tomorrow as well. Now, before I get into the entire discussion of section 73, I will give you an idea as to why is this so important for us to discuss. Okay, so let's try to understand a particular situation. And this will tell you holistically the entire concept of compensation and what is the need of discussing this compensation here. So let's say we have two parties. We have A and we have B. Okay. A is an employer, let's say employer or a master of a particular company. He knows that now there's going to be New Year's. And for this New Year's, on 30th of January, he has asked B to deliver pen drives to him. Now, what is he going to do with pen drives? And not just one pen drive. He has asked him that please give me 50 pen drives. On what date? On 30th of January. They decide on an amount of money also, and they say that I will give you 50,000 for 50 pen drives that you will be delivering to me. He does not tell B that the pen drives are not needed for my own use. Rather, because I have a meeting with my employees on 30th of January. And he is going to gift these pen drive to his employees. So how nice of a master A is. But what happens here is that B on 30th of January makes a call to A and tells him, I will not be able to deliver these pen drives to you today. So has B breached the contract? We have to understand that. And if at all B has breached the contract, what is A supposed to do? So to move forward in our question and in our hypothetical case, we see that A immediately, because he has to give those gifts to his employees, he immediately calls 3 other business people who are dealing with pen drives. He asks them to provide him a quotation as to how much will they charge him for 50 pen drives to be delivered today itself on 30th of January. Now, these 3 quotations, out of all the 3 quotations, one best quotation that he gets is of 55,000. So A gets happy. He thinks that, okay, not much of a loss, just 5,000. This I will later get from B. He takes the pen drives and gifts it to his employees, and the employees go happy for their New Year break. But now A wants to sue B. And why does he want to sue B? He says, you remember the promise that you made. You took an obligation that you will be delivering these 50 pen drives for 50,000 of rupees. And you have not done so. So there is breach of contract that has happened. Now, in such a case, what are the different set of remedies that you would like to offer? So let's try to understand from whatever limited knowledge we have so far. If A wants to sue B, can the court ask A that, okay, we understand that you had to pay 5,000 extra. We will give you monetary compensation. Okay. How much loss happened to you? The market price on 30th of January was 55,000 for the pen drive. The contract price, okay, please remember the terms that I'm using. Market price on the day of breach is what? 55,000. The contract price decided between them is 50,000. So the court may say that, okay, we'll happily give you 5,000 of rupees and you be happy about this. I'll come back to this and discuss that why monetary compensation is important when we talk about commercial laws. Okay. The second remedy can be that B is asked by the court that please, you made a promise, you specifically perform the promise and you deliver 50 pen drives to A. Now, do you think it will be fair if we ask B To specifically do what? To specifically perform the promise that he has made. That you promised delivery of 50 pen drives, please do the same. Will it be unfair to both the parties now? It can be. It can be unfair to A because he has already fulfilled the purpose for which he required the pen drive. It can also be unfair for B because there can be X or Y reasons for why B was not able to deliver the pen drive when he made the call on 30th of January and informed A about it. Maybe there's strike of his employees, the manufacturers has not delivered the pen drives to B. There could be any reason. So specific performance also may not look as the best remedy in this case. Now, the third illustration in this particular given set of facts can be, which will be very important for us to understand, that what if the quotation that A sought from these three business people and the quotation that he gets is of 48,000. Isn't it beneficial for A? A was expecting to get 50 pen drives for 50,000. But on 30th of January, when B decides to not deliver the pen drive, there is a third party C who delivers those pen drives at 48,000, benefiting A of how much rupees? 2,000 rupees. Still A goes to the court and sues B for breach of contract. He says, what if I got a benefit of 2,000? It's okay. This 2,000 is separate from this transaction. You did a breach and you should be penalized for this breach. Okay, what is the term that I've written? Penalized. There must be a penalty imposed on you and you should still be asked to pay me 5,000 or 10,000, whatever amount of money he thinks is normal for him to get in this situation. So in these three cases, what can we see? That even in a situation where no monetary loss, where there is no difference between the market price and the contract price, can he go to the court and ask for a remedy or ask for compensation? This is our first question. The second question is that why or whether such specific performance will be allowed here or not. This is something which we will deal and which we will understand under Specific Relief Act of 1963. And this is the discussion of our today's class. That why should we granting monetary compensation of 5,000 rupees to A by B, it should be paid in this given set of facts. So I hope you have understood this problem that I have shared with you. This is not specifically coming from any case law. This is a problem by which you actually think on your toes and you try to understand that there can be multiple facets, multiple remedies. There can be a situation where there is no monetary loss that may have happened. Still, you can go to the court. Still, you would want to go to the court and ask for remedy. And these are the type of problems that you can expect to get in your exams as well. So keeping this in mind, wherein we spoke about monetary compensation, let's try to read it from a particular case law. Now, how do I actually teach? First is that I will be referring to this PDF that you can see over here. I will scribble and I will write over here whenever we read the case laws. In addition to this, I will also be showing you documents, okay? Because we have paucity of time and we have to read the judgment and the important context from the judgment, I will be referring to the PDFs of the judgment here, in which I have highlighted the essential portion that you're supposed to read, remember, and write in your exam. So the first judgment that I'm opening here is in context of why monetary compensation is essential for us to be, giving to the party who is aggrieved. If you refer to the pink part of this particular judgment, I'll just show you the name of the case also. This is the name of the case law, Ruxley Electronics and Construction Limited versus Forsyth, okay? But here we have to understand the idea given by the judiciary is that whenever in a commercial context, we talk about, is this a commercial context where A and B have entered into a contract for buying or purchase of pen drive? Yes. So in a commercial context, These criteria, the criteria with respect to finding the remedy, normally proceed on the assumption that each contracting party's interest in the bargain was purely commercial and the loss resulting from a breach of contract is measurable purely by economic terms. So here, the important aspect or the important idea that we have to gather is that whenever we speak of a commercial transaction, the idea is to restitute the person to the original position. Had this loss not happened, if B would have actually delivered the promised pen drives to A on the 30th of December, what was the position, what is the position that A would have been in? So there would have been no loss of 5,000 rupees, right? So in a commercial transaction, we try to make good to the party by restituting, by restoring them to their original position. So with this in mind, we have section 73, okay? So when we talk about compensation that is to be granted in the previous case, when we say market price was 55,000, contract price was 50,000, what is the amount of compensation that is to be given? In that context, we have to now refer to section 73 of the Indian Contract Act. Now, there can be two ways of reading section 73. Either we read section 73 and then we go to a very important landmark judgment of Hadley versus Baxendale, or I tell you the fact of Hadley versus Baxendale and then we come back and read section 73. So we are going to opt for the second method, okay? And why is that going to be helpful? I'll tell you. Do you see this question that I have put here? This has been asked in a judiciary examination only, wherein the question was, explain giving suitable examples the rule of Hadley versus Baxendale. Okay, we will read the judgment and we will be able to answer with suitable examples. But the second part of the questions discuss the extent of its applicability in India. How far is Hadley versus Baxendale applicable in India? This answer you get when you read Hadley versus Baxendale in context of section 73. Okay, so I'm going to tell you the facts of the case and then we go back and read section 73 and find out how much applicability of the rule given under Hadley versus Baxendale is present in section 73. Okay, so we have to keep the questions in mind. When you're preparing for your judiciary examination, please remember a few key points. Are you supposed to read from the Bare Act? Yes. As I told you, there are 18 illustrations mentioned in the Bare Act itself. Okay, I'll give you another question that can be possibly asked. What thing that I have highlighted here? Or they can simply ask you whether section 73, everything will be same, and they may mention and, or either section 73 uses the term or does it uses the term and. So you have to firstly be very thorough with your Bare Act. And when we say Bare Act reading, we do not expect you to mug up the Bare Act. If you understand section 73, you will never get confused with and or in this given situation. Okay, that is the first. Second is you have to refer to the previous year questions. Now you see that there have been notifications that have come out recently for the judiciary examination. Please stick to the previous year questions when you have paucity of time. Try to understand that what sort of questions are asked. Like I am telling you over here, this is a type of question. You may read Hadley versus Baxendale. You may read section 73. But do you really understand that how far is that applicable? You have to read it in the context of the question as well. So that is why we are going to first understand what happened in Hadley versus Baxendale. And then we go back and try to read section 73. Okay. So what has happened in Hadley versus Baxendale? I'll just draw the facts for you. We have Hadley. They had a mill, okay? And in this mill, they had a particular steam engine. This steam engine had a part within it, which was the crankshaft. Now, if you start seeing the previous year questions, you will see that the same terms, same devices, crankshaft, carriages, transporters, all the same set of facts can be, can be asked in a given set of question. So Hadley had a mill, and the mill it was a flour mill, okay? So the flour mill used to have a steam engine, and the steam engine would work on a crankshaft. Now what happened to this crankshaft? Hadley one day finds that the crankshaft stopped working, and now they had to get a new crankshaft prepared. Now the case has been decided in 1854. So you have to understand that technology back in 1854 was not so developed that they had to actually send this old crankshaft as a model for the new one to be prepared to the engineers who actually made this. The engineers used to live in Greenwich, and Hadley was in the mill was situated in Gloucester. If you see, the distance between them is quite a lot, okay, 160 kilometers or so. So they realize that we cannot actually transport it immediately to the engineers. So we will now take help of a transport service. So they get into a contract with a transport service. They very clearly tell them that we want this to be delivered to our engineers at Greenwich, who are going to use this old crankshaft and prepare a new one for us. The transporters are actually represented by Baxendale. That is the name of the case law, Hadley versus Baxendale. Now what happened with Baxendale? He promised that, sir, don't worry, I will deliver your crankshaft in 1 day to the engineers. How am I going to do that? I am going to use railways for this particular transport. And he also takes £2 from them for the transportation charges. Okay, all good so far. Now what actually happens here? This is something that they promised. Baxendale promised this. But what did he actually do? He rather opted for canal. Now, if you are sending the crankshaft by canal, obviously there will be delay. So rather than taking 1 day time, it took 1 week of time for the delivery of the crankshaft to be done. Now there is delay. The mill was not working for this entire duration. And now a case has been filed by asking for remedy, asking for a compensation to be given. How much compensation do you know? £300. They say, we paid you £2, that is fine. But the loss that has happened to us because our mill did not work. And why did it not work? Because you delayed in delivering of the crankshaft. For this reason, we want you to pay us for the loss that has happened for our profit. Okay. So you see, the two terms are coming together, profit and loss. But what are they claiming here? They are saying we have come through, we have faced some losses because of the profit that we were expected to make in the period which you actually delayed, and because of your negligence, this has happened. Now, what do you think should happen? Should they be granted this compensation, this extravagant compensation, or should they not be granted this compensation? I will take a minute's time to open my document. Till that, you can drop your comment in the comment section that compensation should be granted or it should not be granted. Now, if we see the proper rule in the present context, okay? Now, this is 1854, as I said. 1872 is when we codified our law. We kept the rule given by the judges in this particular case. And we say here, where two parties have made a contract, which one of them has broken, the damages which the other party ought to receive, okay? The ought to receive is which they are expected to receive in respect of such breach of contract should be such as may fairly and reasonably be considered. So what is important? If there is a breach has happened, yes, 1 day was extended to 1 week. So if there is a breach that has happened, the damages will be assessed as may fairly and reasonably be considered. That is first point. The second is either arising naturally according to the usual course of the things from which the breach of contract itself occurs. So first essential point, if I have to jot down here, is what is occurring fairly and reasonably, right? Arising out of a natural course or a usual course of thing. So is this usual course of thing? The court had to ask them. The court had to ask Baxendale, what did you think when you delayed the delivery by 1 week? So is this usual and natural? Baxendale to answer said that I did not have any idea that the mill itself will not work. Baxendale said that there can be other reasons also by which the mill may not work. Even if I come and visit and see that the mill is not working, is it only because of the crankshaft? How do I know? You are expected to keep a spare crankshaft. I can presume and I can believe that you have a spare crankshaft. Did you put this additional knowledge in my mind? As we discussed in our first example of pen drives, did A tell B that I need the pen drives to be delivered because I have to gift it to my employees? So the purpose or the special circumstances that the mill will not work till you provide the crankshaft to us was also not disclosed to Baxendale. And from this, there were two different categories that were carved out with respect to a breach of contract that happens and the compensation that is to be granted in the general course of nature. And if you see this paragraph that I've written over here from the judgment, this has also been asked a lot of times previously. Okay, so please read this paragraph along with me, because this is what you will see is present in section 73 as well. And this is something that is time and again asked in previous year questions as well. They will give you the paragraph and they will ask you to explain. Now, what will you explain in this? You will explain the two categories that are mentioned for the compensation that may arise. Okay, let's read. Where two parties have made a contract and the contract gets broken, the damages which the other party ought to receive in respect of the breach should be as may fairly and reasonably be considered, either arising naturally according to the usual course of things from the breach of contract itself. I know this must be sounding very confusing right now, that what is usual course of thing, ma'am, what is naturally arising. So we will discuss this. Okay, we have illustrations, we have case laws by which we will understand the first part. But right now, we are only and only trying to understand that there are two categorization by which we can divide the compensation that will be granted. The second is, or such as may reasonably be supposed to have been in contemplation of both the parties at the time they made the contract as probable result of breach of it. Okay. Contemplation of both the parties, does the contemplation has to be expressed or can it be implied also? This is also one thing that we need to discuss, right? So we will understand this from case laws. At what time? At the time they made the contract. You will find questions coming from this part as well, that the contemplation of the parties at any time or at the time when they made the contract. So remember this as well. Okay, as probable result, they have not discussed it, they have not put a clause with respect to liquidated damages in the contract, but this is a probable result of the breach of such a situation. Remember, I just spoke of a term, liquidated damages. Those who understand liquidated versus unliquidated damages can drop their answers in the chat box. I will just take a moment to tell you that we will be discussing this category of damages later. Okay, in our 3-day series, we will be talking about liquidated damages. But herein, we are only covering unliquidated damages. What are liquidated and unliquidated? Simply put, liquidated is pre-decided. When the parties to the contract decide that in case of a breach, this much compensation will be granted. Now, whether that compensation only will be granted, can it be lesser, can it be more than that? All is this discussion that we are going to do later. But we have to understand that what are the probable causes basically hinting at the concept of unliquidated damages. That even though it was not so decided, the parties could probably understand at that point of time that this much of compensation or this can possibly lead into breach of contract in this given situation. So this is the excerpt from Hadley versus Baxendale that we have understood. Now, if you read section 73 now, please tell me whether you find any similarity or not. When a contract has been broken, the party who suffers by such breach is entitled to receive from the party who has broken the contract compensation for any loss or damage caused to him thereby, which naturally arose in the usual course of things from such breach, or which the parties knew, both the parties knew when they made the contract, likely to result from the breach of it. Likely to result, probable. So section 73, when you get a question, you can divide these two parts. You can refer to Hadley versus Baxendale and support and say that it has been taken, or it is the foundation of section 73 comes from Hadley versus Baxendale. Now I've mentioned the definition of damages for your answer perspective, because I come across a question wherein they had asked that what is the distinction between damages, unliquidated damages, and liquidated damages, okay, or damages and penalty. So for that, when you get a question of damages and penalty, we will cover penalty later. What we are discussing right now is damages of different nature, liquidated or unliquidated, actual or which are in special circumstances that may arise. So that is why I've started with definition of damages. Oxford Dictionary describes damages as financial compensation for loss or injury. Okay, financial compensation. The pen drive example, monetary compensation, right? We are referring to the same. The pecuniary compensation obtained by success in an action. The damages will be granted to you when you file a suit and when you succeed in the suit, right? So we have to see the chronology also to understand that there will be filing of a suit, then the entire trial will happen, and then accordingly, if you succeed, the pecuniary compensation will be granted to you, which is also called as damages. Now, as we discussed in the beginning, the two problems that we face with respect to damages is the remoteness of damage and the measure of damage. Okay, these are two very essential points and the threshold for us to decide that if the party has committed breach, till what extent do we make them liable? Secondly, what will be the measure of the damages? How much damages will be granted? So this is what we have designated as our topic for day 2 of our lecture series. Now we move ahead and we see that section 73, the 2 points that we had written, can be classified into general and special damages. The one that is arising naturally in the usual course is called as general damages. The one wherein both the parties have to have contemplation. They need to know, I must have conveyed it to the other party that if this situation arises, this will be the consequence of the same. In Hadley versus Baxendale, if Hadley would have told Baxendale that please return the crankshaft within 2 days to me, otherwise my mill will not work till the time you actually deliver the crankshaft. Now these are what? These are special circumstances, unusual circumstances wherein you have to put the knowledge to the other party for them to understand the possibility of the special loss. Okay, so this is again coming from section 73 only. That's why we've just written it with two categorization, that one can be called as general damages, the first part of section 73. The other is called as special damages. Now we have illustrations. This is for your help that I have mentioned that what illustrations actually discuss and which covers actual damages and which covers special damages or indirect damages. So these are the illustration numbers that I've put from the Contract Acts itself. I've mentioned 3-4 of it, but I'll just pick one right now because we have to deal with case laws as well. So let's just take one and understand how is this usual and how is it special in the other case. So when I talk about actual damages in usual course, okay, let's see what is happening here. A contracts to sell and deliver to B on the 1st of January certain cloth, okay, certain cloth which B intends to manufacture into caps of a particular kind. B has decided that if I'm going to, now 1st of January is the season of caps, right? So he expects that when I get this cloth, I will immediately make caps and I will sell it in the society, for which there is no demand except of that particular season. So the entire benefit that B is going to make or generate out of this is based on the timely delivery of the cloth for him to make the caps later. The cloth is not delivered till after the appointed time. So it did not get delivered on the designated time and delivered so late that it could not be used in that year for making of the caps. B is entitled to what sort of relief? Okay. Can B take the compensation for late delivery? Can B take the compensation for the profit B would have made if he would have sold this entire lot of caps? We have to find that out and then distinguish whether this is usual course of breach or whether this is special damages wherein both the party contemplated something. Now, if you get a similar illustration or a similar question, do you find any sharing of idea from B to A that I am going to make a cap, so please deliver it in this particular season, or please do not delay the delivery? Nothing of that sort is mentioned here. Therefore, it gives us an idea that B will be entitled to receive from A the difference between the contract price and the market price of the delivery, and not the profit which he expected from making of the caps. So let's say, what is B expected to do if the timely delivery is not done of the cloth? He is expected to immediately look for a option. Does the law protect those who sleep over their rights, or it protects those who are vigilant about their rights? Vigilant people, right? So there's a maxim also which we read, which is vigilantibus non dormantibus, right? Which basically says that you have to be vigilant. So B in this particular situation is expected to be vigilant of his rights. And that is why if he now goes immediately on 1st of January and he gets a cloth at a higher price, the compensation that he is expected to get in this case is the difference between the market price and the contract price and nothing else. And that is why this is this has been categorized as actual damages in usual course of nature. Okay. So this is one illustration that we have discussed. This is the illustration from the Indian Contract Act itself. So you can find it under illustration Q. There are more illustrations like R and N that I have mentioned over here. The indirect damages or the loss of profits can also be sought. Okay. So you can actually say that not just the breach that has happened and the compensation that I'm expected to get, but also the loss of profits can be received, provided you do what? You share your idea with respect to the business to the other party. So let's try to understand it from this particular illustration K. A contracts with B to make and deliver to B at a fixed day for a specified price a certain piece of machinery. Okay. A does not deliver the piece of machinery at the time specified, and in consequence of this, B is obliged to procure another machinery at a higher price than that of which A would have paid. So hypothetically, I say that A had promised to B that I will give you the machinery for 5,000. And when he did not deliver it on the designated day, B had to get it from C for, let's say, 6,000. Okay. And is prevented from performing a contract which B had made with a third person at the time his contract with A. So what happened here? B also had a contract with X, a third person in this transaction, right? B had promised X that I will be giving you caps. How is he going to make the cap? With the machinery that is going to be delivered to him. Because the machinery did not get delivered, he was also not able to give the caps to X. But what is important here, if you refer to the illustration K from section 73 of Indian Contract Act, it says, but which had not been communicated to A. Did you tell about your idea? Did you tell about this idea or your contract with X to A? You did not. If you have not told him, you cannot really ask for the loss that has happened to you with breach of this contract. But if he would have told A, will he be entitled to get compensation for this breach as well? He can get entitled for this. Okay, so that is why it is very important that when we talk about special damages, the idea or the information or the knowledge must be shared between parties. Now, if you remember in the beginning, I had highlighted knowledge to be of two nature. It can be either expressed or it can be implied, right? So now we'll read the case laws from which we find out whether and in what situation can the knowledge be considered to be implied in a given set of facts. Okay, so we have so far covered what all? We understood Hadley versus Baxendale. We concluded that Hadley versus Baxendale is the idea which is the foundation of section 73. We have multiple coming judgments by which we have interpreted how this knowledge expressed or implied is going to be seen in context of the facts. We have also referred to certain illustrations from the Indian Contract Act to understand that what are general damages and what are special damages. Okay, now take a moment and try to answer this question. Okay, I've put a question in front of you. You have to find the best answer from this. You can drop your answer in the chat box, A, B, C, or D, whichever you think is correct. I'll read out the facts for you. X agreed to supply 1000 tons of iron at rupees 100 per ton to Y. Okay, to be delivered not later than 31st January 2002. So this is also from a previous year question, where X has agreed to Y that I will be delivering this much of quantity at this much of price on this particular specified date. X also entered into a contract with A. So there are three parties now. Okay, we have Y, we have A, and we have X. X also has a contract with A for the purchase of 1000 tons of iron at rupees 80 per ton, telling A very clearly that the iron is needed before 31st January 2002. So X knows that he's going to get the iron from A and he's then going to supply it to Y. So there are three parties. For it to be supplied, he has also told his idea or his existence of a contract with Y, that only and only if you give this, I'll be able to supply it to Y to fulfill my contract with Y. A fails to supply the iron to X, who in turn fails to supply it to Y. So we understand that there is a breach of contract that A has done towards X, and consequently X has also breached the contract with Y. In this case, what is the compensation that X can seek from A from all the things that we have covered so far? Try to give your answer. Option A is X can recover damages for the loss of profit at the rate of 20 rupees per ton. That is the loss of profit. If A would have delivered the iron on time to X, he would have made benefit of 20 rupees per ton by transferring it to Y. So he could not get this profit and therefore loss of profit has happened. Option B, X can recover damages for the loss of profit that he would have earned by timely supply. So this 20 rupees per ton, and also damages which X might have paid to Y in account of breach of contract. So can he also take the compensation that he had to pay to Y for breach of contract? So can he ask for loss plus the amount of damages that he has had to pay to Y because of the consequent failure? Option C, X can recover damages which X might have paid to Y on account of breach of contract. Will it only be damages? X can recover damages in the form of penalty. Okay, so you have to drop your answers in the chat box for me to know how far you have understood of what we have discussed so far in our class. Okay, so I'm leaving now you with your answers, and then we move to the different case laws that have been covered, which takes us forward from the Hadley versus Baxendale rule. So there are two set of rules, as we understood, which can be simply put as general damages and special damages. General damages are what? That are naturally arising in the usual course of things. Okay. Special damages are what? Wherein both the parties have knowledge, and the knowledge can be either expressed or implied. Now the first leg of Hadley versus Baxendale, usual damages, has this particular case law. Okay, so we start with our discussion on this particular case law. The facts are a little different, and that is how we come to a different conclusion also. So this laundry service that is there, they enter into a contract with Newman Industries Limited. So I will name them as NIL, Mill, and I will name this as Victoria. Victoria enters into a contract with NIL for what? They say that I need a boiler. What do they need the boiler for? They tell them the idea that, listen, I am planning to expand my business, and accordingly I will be making this much of profit. I have so many clientele that are coming now, and for all my clients I will be making a profit if you deliver the boiler to me on time. So designated time was also decided, the purchase was done, and the delivery was due. The delivery was delayed, and because of this delayed delivery, Victoria had to incur what? Loss of profit. They could not earn the profit that they were expecting to make out of this particular boiler. Now, not just this, Victoria was also expecting that they have an expected contract, a very good beneficial contract, which is going to help their business a lot. And this beneficial contract also could not materialize. Why? Because of the delayed delivery done by Newman Industries Limited. Now, in this case, in this particular suit, Victoria asked for two set of damages. First is for loss of profit, and the second is for the loss of the beneficial or the business opportunities that had happened to Victoria Laundry Limited. Okay. Now, what do you think should happen here? Is this something that was told to Newman Industries Limited? Was this shared with them? Yes. Was this shared with them? No. Is this something that they were reasonably expected to know? Do you think they are supposed to reasonably know that you are going to have a contract now with X, Y, and Z parties? Not really, right? That is why we have categorized this case in the first heading, and we say that these are damages arising from usual course of thing. This is not usual, right? This is not usual. This is something special that you must have informed them that, listen, I have a contract, I have an upcoming opportunity, business opportunity, and I expect you to make the delivery of the boiler in time. So if we refer to this judgment, we'll just take the essential or the important part of it. The court here has highlighted, it is well settled that the governing purpose of damages is to put the party whose rights have been violated in the same position so far as money can do, as if his right have been observed. Okay. Now, important part after this as well. The primary aim or principle of law of damages for breach of contract is to place the plaintiff in the same position. This is the primary object. You making extravagant benefit. You not telling the party and then burdening them with certain things is not the benefit. We do not wish to penalize the party. Do you think penalty is something that we intend to do here? No. That is why it is called as Indian Contract Act. We categorize this under civil law, right? So in this particular case, the court realized that this is usual damages will be granted. This should be allowed, but not the other set of thing which was not informed to the party. Okay. Now going to the next case law. There's one more aspect that I found very important here, and I'll tell you why am I discussing this. Okay. So let me just highlight this. I'll tell you. If we summarize, the defendant knew that the plaintiffs were launderers who wanted the boiler for immediate use. So they were told that we want it immediately. They were told that there's going to be loss of profit. The Court of Appeal held under these circumstances that defendant as a reasonable man could have foreseen some loss of profit, though not the loss of special contract of dying, of which he had no knowledge. Okay, so the first thing, it can be there because this was told to them. But for the second thing of the special contract of the business agreement of dying that they had, this will not be applicable. Now, this is something which is very important. And let me tell you why we are discussing it here. If you refer to the previous year question, there was a question with respect to, and this is asked very recently only, wherein they say that what is the difference of compensation or damages granted under Contract Act versus tort law? So whenever you are reading civil laws, always remember, always make comparison, okay, and always try to remember this when you read torts. When you're reading torts, try to recall what you have studied in contract law. Now here, the judgment said, the court said that it is also clarified that mere knowledge was not enough. It should have been brought to the knowledge of the defendant that he accepts the contract with knowledge. Okay. The party knew, the opponent or the defendant party, NIL, knew in this given situation that you have a contract and you have so many clients coming to you. That knowledge is fine. But along with that knowledge, there must be something to show that you have accepted the terms of the contract, that you have accepted that you will make the timely delivery, or in case of a breach, you are going to pay compensation. Now, please, if you can recall of something from the torts class, drop your answers here. How is this related to any principle in tortious liability? I'll just give you a hint also. Mere knowledge was not enough. So therein we have a defense of voluntary non-fit injuria. In torts, you refer to this defense. Voluntary non-fit injuria is voluntarily, if you take the risk, you cannot say that there has been legal injury that has happened to you. It is something related to this, where you accept the contract with that knowledge. So how is voluntary non-fit injuria different from the other concept that I am actually asking you to write in the chat box? Please write your answers if you know it. I would love to know. And otherwise, please ask me this by the end so that I remember and I tell you how is this related. So even though different, but we all keep relating things, whatever we find has some nexus with the other topic, mere knowledge, and this just took me to my torts class. Okay. Now we have next case law, that is Kufos versus Zarnikol Limited. Now what has happened here? There was supposed to be, now see how the facts change everything. Okay. There is one party which has entered into contract with the other party with respect to transport of sugar to be done. Okay. Transport of sugar is to be done at a place which is called as Basra. And both the parties are very well aware that Basra is famous for selling of sugar. This is a place, this has a big market wherein every trader comes and they sell the sugar. So the plaintiff wanted the transport of sugar to be done to this particular place, Basra, at a particular designated time. Now, the party promised that and they later accepted also during the trial that the usual time of delivery is 20 days from the place of pickup to Basra. But because of the defendant's negligence, it was delayed by 9 days. Okay, it reaches the market after 9 days. And therefore, the plaintiff, when they tried to sell it, they had to sell it at a very lower price. And why did lower price? Because the market changed. Okay, the market price changed. Market price changed because their competitive ships had also arrived with sugar in it. And therefore, the plaintiff had no option but to sell their sugar at a lower price. And for the difference of the lower price, now they want to sue this particular defendant for the negligence that they have done, for this particular breach that has happened by delivering the sugar after 9 days. Now, what do you think should happen here? The court highlighted and the court said that we have to see the knowledge. Do you remember knowledge can be imputed or knowledge has to be expressed? Even though the plaintiff did not tell him that I am taking the sugar to Basra for selling purposes, was it known to the other person? Yes. Is a reasonable person expected to know that this particular reasonable man is a reasonable prudent person in the given set of facts expected to know that the sugar is being taken to the market for sale purpose? Of course, yes. And are they also expected to know that there is going to be fluctuation of price in the market? Yes. So in such a situation, you have to pay for these compensation as well. Okay, the compensation for the difference of the price that has happened in this given situation, because any reasonable prudent person would have impliedly understood that if I am delaying, if because of my negligence, if because I am deviating the route and trying to save my fuel, this is going to cost my other client, that is Hufos, in this given situation. So that is how section 73 was construed in this particular case. And the court said that you are supposed to pay them for the damages. Now, I've just highlighted one aspect from this judgment. Lord Wright has said and referred to cases where it would not be fair or reasonable to hold the defendant responsible for losses which he could not be taken to contemplate as likely to result from his breach of contract. So again, it's very factual. In this given case, you are a trader, you are a transport service person, you are supposed to know, you ought to know that if you're going to delay delivery of the sugar in the market, it is definitely going to cost to your client, right? So it has to depend on the facts as to whether it will be fair and reasonable to make the defendant liable for the losses of breach of contract. Okay, now we go back. So these are different rules that have been laid down in this particular case that I have mentioned over here, that in case of a breach of contract, the aggrieved party is only entitled to recover such part of the loss actually resulting as was at the time of the contract reasonably foreseeable. In tomorrow's class, we are going to discuss about foreseeability and remoteness of damages. But just to summarize and understand in this context of actual and special damages, we are reading this particular case law to conclude and to understand that in this particular case, the person could have reasonably expected and would have known that I'm going to cause loss to the person because of the breach. Okay, knowledge possessed is of two kinds. Very important point. When we speak of the second part of section 73, we are totally relying on the idea shared between two parties. I did not tell you, but were you supposed to know is the knowledge that you possess. It can be of two kinds. One can be imputed and the other can be actual. Actual is when it has been shared with you. Imputed is when I expect you to know out of these ordinary circumstances. Okay. So this was the first set of rules from Hadley versus Baxendale. The second one is where more loss can be asked due to special circumstances. Okay, special circumstances has to be put before the parties for it to be held liable. Let's understand this particular case law. if you're aware, there are good 5-star hotels here in Delhi wherein a lot of exhibition come sale happens. Okay, so this fact is can be related to that particular exhibition come sale. If let's say X is here, X or Simpson in this particular given case happened what? Simpson used to, now I give you an example of 5-star hotel, but here it was something different. Okay, so they were selling their cattle food. Now you can't sell that in a 5-star hotel. So this cattle food was to be taken for a exhibition come sale. And they told the transporters also, they told the Northwestern Railway that listen, we go and we participate in this exhibition come sale every year, and you are supposed and you're expected to take our cattle food there. Not just this, they also attached a note to the entire box of cattle food. They said that it must reach to the place of exhibition before Tuesday. Now, this is knowledge imputed. This is special circumstances that we have referred over here. What are special circumstances? These are the special circumstances that we are discussing about. Okay. So they have put a note also to give them knowledge that please get it delivered before this exhibition come sale gets over. But again, bad habits die hard. So they did not deliver it on time. And again, Simpson had to go through a lot of losses. The loss of profit that happened that they could have generated if the exhibition come sale would have happened on time. In this case also, the court referred to the object of sale. Okay, what is the idea and whether the idea was shared with you or not. So this is a very important aspect which we must understand when we read this. Let's just read the important essential here, the highlighted part. The object of the sender, okay, was similarly brought to the notice of the carrier. So it's in this entire situation, the carrier service was told about the object of the sender, that I want to take part in this exhibition come sale. Or the circumstances were known to the carrier from which the object ought in reason to have been inferred. In the previous example, as we just said, that it was expected to have been told to you, right? So either this or the circumstances were such that were known to the carrier from which the object ought to in reason to have been inferred, so that the object might be taken to have been within the contemplation of both the parties. Damages could only be recovered for the natural consequences of failure of that object. So your object can be, again, it can be expressed or it can be implied. If you are telling, if the sender is telling about the object of the sender has been specifically brought to the notice of the carrier. Otherwise, the circumstances are such that are making the carrier know and understand about the object in the given situation. In both the cases, we will refer and we will understand that there can be compensation can be granted provided it was shared with the other person expressly or implied. Okay, now in today's discussion, this will be our last case law that we are discussing. This is much later in 1952, wherein there were, this party had sent their through railways, they had sent their units, different units of the magazine. Now, different units, 3 parts were sent. So let's say part 1, part 2, and part 4 of a series of book that had 8 parts in total. Now, when these 3 parts were sent, they were misplaced by the railways. And now when this was misplaced, the party says that I do not want compensation only for these 3 parts, rather for the entire 8 parts. Now, why so? They say there is no point for me now giving away the other leftover 5 parts. Why? Because these are all intertwined and interrelated to each other, and I cannot really do anything with the leftover parts. So what do you think? Compensation for 3 parts should be given, or should it be given for the entire 8 parts of that particular book? So I'll just refer and I'll just show you the judgment also. The question then is whether the applicant is liable for the cost of only the 3 volumes or the cost of the entire 8 set of this particular transaction. The court said here that the loss of the entire set cannot be regarded as the loss naturally arising in the usual course of things. Tell me something. When you in your invoice are mentioning that these are bulk of books, okay, the invoice was also presented. These are bulk of books. Are they supposed to understand that these are books which are related to an entire series, and this is something that, you know, they are expected to pay you off if the books get misplaced? No. So therefore, the court said that reasonably in this given situation, it does not arise in the usual course of thing that we pay you damages for the entire 8 lot of the entire 8 series of the books. And that is how the court only granted compensation for the 3 lost books that were there. Now, these are questions that we will finally discuss, and we will end our class with this. But before I go to the question, let me just quickly rewind and tell you what we have discussed today. We refer to section 73. Section 73 has an explanation, which we will be discussing later. Section 3 has a second part, which we again will be discussing in tomorrow's class, which talks about remoteness and measure. But in today's class, we have tried to understand only section 73 in context of what are general and what are special damages. Okay, these are 2 damages, even though it doesn't say, you do not find general damages written in the bare provision, but this is how we have categorized them, seeing that the foundation of section 73 is coming from Hadley versus Baxendale. Then we refer to the case laws also, which tells us that in first given situation, there can be cases where you have to tell the other party, okay, where you are supposed to tell the other party for you to get compensation for special circumstances. But if it is something which is in the usual course of thing, like an example of railways, in usual course of thing, whatever I have given to the railway, the railways expect that if I displace this or if I, lose this, I will only be paying compensation for this thing. They do not expect to give you compensation for other set of things also, which is not reasonably foreseeable for them to expect. So general and special damages can be based on the idea of what special knowledge you have given to the other party. Now, keeping this in mind, we have very important 2 questions over here that we can refer, and you can try to find the answer. And the idea of using these questions at the end is for you to assess that how far has the lecture actually helped you if you get this question in your judiciary examination. Okay. X, a builder, contracts with A to erect and finish a flat for him before 30th June 1997. X is a party. He has contracted with A. X is who? X is a builder. So I will suggest you that whenever you get questions, you try to make diagrams out of it of this sort, not in your exam, but only for your understanding when you are practicing for it. Okay. So even in your exam, if you write it neatly, you can definitely do so. Now, X is a builder who has contracted with A that I will erect and I will finish the flat and give the possession of the flat to you. On what date? On 30th of June of 1997. Okay. In order that X may give possession of the flat by that time to B, to whom A has contracted to let it. A is very smart. He has already contracted with B that I will rent out my house to you. Okay. I will get the possession, and I've already told X that he will deliver the possession of the house to you and it will be rented out to you. Now, the important aspect here is that X knows about this contract between A and B. X is aware about this, right? Now, X is informed of the contract between A and B at the time of entering into the agreement with A. X promised to erect and finish the flat and hand over the possession to B by 30th June. So he is aware, still he makes a promise. Now what does he do? X builds the flat, but builds it with a very low raw rate material and accordingly the flats fall down before 30th June. Okay, so the raw material that was used by X was of very bad quality, and before the possession could be given to B, it actually falls down. A comes into picture. A has to rebuild the house. Okay, A rebuilds the house. He in consequence loses the rent which he had to receive from C, because he could not immediately give the house to C. He loses on the rent. So what all has happened here? He had to rebuild the house, A. And then A loses the rent also. And the third is A is also obliged to make compensation to B for breach of contract. He had also to pay compensation for breach of contract between A and B. Now, what is the remedy that you would advise A to be given from X? How should we, what all, whether this should be granted, this should be granted, or this, or three of these should be granted by X under the purview of section 73 of the Indian Contract Act. So if you see, this is very similar to the judgments that we have discussed in our class today. And this is the question that has been asked in the judiciary. And this is one question that I have used here. There are multiple questions where the parties may change or the subject matter may change, but it may be a flat, it can be a book, it can be other things. But it will evolve around three parties, whether you have given knowledge to this party about this particular contract will change the entire solution for you. Now, the next question is also here. X is a resident of Ambala, is in manufacturing business of household appliances. Okay, so he's a resident of Ambala and he manufactures household appliances. For the past 5 years, he's participating in exhibition cum sale held every year at the Ashoka, New Delhi. So something that you can recall of, right? X used to send his goods through a particular transporter who had knowledge about X participating in exhibition cum sale. So he has a particular transporter also. Every time he uses this particular transporter, who has what? Who has the knowledge about why participating in this particular exhibition cum sale. In 1995, he again delivers him the goods and the same transporter well in time for part. He has been very good in his conduct. If you see, X has made timely delivery of the goods, and he has again told him that I have to participate in this exhibition, mentioning in the consignment about the note. Okay, so very similar to which case law? Please drop your answer in the comment box. If you have prepared notes with me, write down about the answer for this. Okay, so but this time, due to the negligence of the transporter, the goods reach after the exhibition has ended. X files a suit for loss of his freight charges as well as the loss for the profits. So the freight charges that he had to pay using the transport service of Y, as well as the loss of profit that he was expecting to make out of this particular sale that was happening at the Ashoka. How do you think the answer will be here? Okay, do you see similarity with any case law? You have to answer in the comment box as to which case law is related to this given set of facts. Okay, so with this, I am ending today's class. I hope you really like the lecture. You can join me today for discussing another important essential aspect related to compensation, that is reasonability as well as the measure of damages that is to be done. And day after that, we will be talking about penalty and liquidated damages. I must tell you that the recent trend has been to ask a lot of questions from section 74. So do join me. There are a lot of recent developments that have happened in that particular area, which we will try to simplify and discuss it with you. Thank you so much. I would now like to take your questions. Okay, so you can drop your questions in the comment box as well, and I would love to answer it tomorrow's class or later also. Please feel free. Please prepare your notes on the basis of the discussion that we have done today, and accordingly, we'll meet tomorrow again at the same time. Hope to see you soon again tomorrow. Thank you so much, all of you.